Let's stay with us and speak to Mpumelelo Zikalala, who's a legal analyst. Kuzen, thank you so much for your time this afternoon. Now, the issue of bias is front and center in these particular arguments. Now, the president's lawyers arguing that there is no case of bias here or apprehension of bias. I wonder, what are your thoughts on this very crucial argument?
Yeah, I think that the argument will have to center with how our courts have dealt with the element of biasness in the previous occasions. Now, our courts have said that we look at the element of bias from the person who is the applicant. So it's not the actual bias that we are looking for, it's the reasonable apprehension of bias. So in this case, one can argue, I send you questions asking me about investigation within the Phala farm. The next occasion, I receive a letter stating that I've been suspended. A reasonable application could be, you are suspending me because you can see there's an investigation which I'm conducting at the end of the day. I think the president's lawyers have seen to this particular fact, and they are conceding to this fact, which is why they are sort of moving the argument to then saying, then look at the intention of the suspension and what harm we're trying to prevent from taking place, and simply focus on that rather than the person who pressed the green button. The harm is still there. If you say that Advocate Mkhwebane must go back to work, then the harm is going to be realized. So whatever decision that you are going to take as a constitutional court, think about the implications of your decisions. That's what I got from the argument when they were arguing earlier on in the day.
And the time lapsed between the written representations in March as well as June appears to also be, quite top of mind for all these legal teams. And the DA, as well as the president's lawyers, arguing that the suspension was not hasty. There were quite a number of things that happened between March and June. But I suppose Mkhwebane's lawyers disagree with this. How much of the arguments that we're seeing this afternoon hinge on this particular matter for this case to be decided as well?
They are going to hinge on the time lapse. Let's remember the test is being used with the reasonable apprehension of bias from the basis of the applicant. So that, in fact, weighs in favor of the public protector, because at the end of the day, the public protector is going to say, you see, at the time in which you wrote those questions to me, you haven't yet taken a decision of whether you want to suspend me or not. However, after receiving those questions, that fast-tracked your desire to then suspend me. So I have reasonable apprehension to believe that whether I responded to those questions, earlier or now, what was the real motivating factor was not the fact that you want to protect the office of the public protector, was the fact that there's an investigation which was pending against you, a number of questions that have been submitted to you, and you're trying by all means to remove me from being at the controlling face of this investigation, and if someone else is going to come in with the maybe apprehension that they're not going to do the investigation in the same manner in which I'm doing it. Hence, which is why I thought that the present legal representatives have also conceded to the fact that no, there is reasonable bias that can be perceived and which has been proved. However, let's move on to the next best prize of saying that if we're not going to win on that particular leg, let's win on the leg of the public protection not going back to work. And we're going to emphasize the fact that what we're trying to do here is to prevent the harm from taking place. Hence, if you allow the public protector to go back to work, it's going to have a direct and dire impact in the investigations and the Section 194 inquiry which are currently taking place.
And of course, they even talk about the credibility of that office if she's allowed to go back to work. And also, interestingly, as you say, they say anything but her returning to work. And another thing I found interesting with the arguments when they were conceding that there might be a perception of bias here is that Section 194 of the Constitution is very clear that the president is the one who has the power to suspend the public protector. And of course, her lawyers as well argue that really, this is where the heart of the matter is. But the DA's lawyers and the president's lawyers are arguing that ultimately, if he's found to be biased, then it leaves no one else to suspend her in this particular regard. Is this a potential amendment to this part of the Constitution that you're seeing, or is the court here going to have to make another directive around this particular issue of who else can be able to suspend a public protector in future?
Well, on this one, it's going to be quite a unique one, because in instances where the president can't act, there is an enabling provision that allows another person to then come in or to step in and to make that particular decision. But on this one, it's very specific because Section 194 is directly directing the president to act in these instances, and it leaves no alternative in instances where the public or the president cannot act, which is why then it's going to be important to look at the preventative nature of what the suspension is all about, to look at whether even the suspension having taken place, can the functioning of the Office of the Public Protector still take place? So you are going to win in terms of saying, let's look at the preventative harm in which I was trying to avoid by suspending the public protector. But most importantly, I'm going to give you the assurance that whatever operations are taking place within the Office of the Public Protector can then be able to continue. Added to that is, let's look at the nature of the Section 194 inquiry and the type of witnesses which are being called in to come and give in their evidence. You can't have a situation where you are going to report to the public protector the day before in terms of your duties in the public protector's office, and then the very next day be one of the people who are going to give evidence against her in an inquiry which is taking place. Then the next question would be, are you going to be free enough to give the evidence that you ought to have given earlier had the public protector not been there? If the answer to that is no, then it definitely means that the suspension of the public protector, the intention behind including this particular section in our constitution, was very clear as to what was the intended purpose of such. And if that intended purpose is going to be achieved with the public protector being suspended, regardless of the fact that she was suspended by a president who is, if you look at it from an innocent bystander point of view, a person who's conflicted, then at the end of the day, the court is going to say, well, there may be a bad way in which this particular provision has been written, but we are looking at the motive, we're looking at the preventative nature of this clause, and we are going to allow it to take place.
All right, it's going to be interesting to see how this one plays out, because the nub of the issue is right there, and some of the lawyers are suggesting that probably the deputy president could be the one that does it here. But when one looks at Section 194, it's very specific. So it will be interesting to see how the court works around this particular one. Thank you so much for your time, Cousin. Do appreciate it. That was Mpumelelo Zikalala, a legal analyst, of course, as we are looking at what's happening in the Constitutional Court. Of course, a whole lot of arguments around the suspension of the public protector, and of course the DA's lawyers as well as the president's lawyers really calling for the apex court not to uphold the decision of the lower court, which is the High Court in the Western Cape, that found that the president really in his conduct to suspend the public protector acted in bad faith, and of course that decision was then invalid.